Welcome back to this course on critical learnings on forest and Adivasi rights. This part of the course will deepen our understanding of the basic premise of Forest Rights Act. And in this particular video, we are going to learn the connections between criminal law and the Forest Rights Act. The Constitution of India grants forest dwellers their fundamental rights, while also recognizing their unique status. We will now see how this uniqueness is protected through criminal law. Criminal law in relation to the forests includes a variety of provisions in different statutes like the Indian Forest Act and the Wildlife Protection Act, amongst others. Usually, criminal law is considered distinct from FRA, but they are also innately connected, as we will soon learn in this video. In doing so, we will also have to reckon with the strangeness of criminal law in the forests. We begin with a story from Madhya Pradesh. In 1986, the High Court of Madhya Pradesh had to resolve a serious conflict of ownership. The government of the state was contesting a tribal community of Chainpura village for the ownership of droppings or dung of cattle. The cattle belonged to the tribe, but as they were grazing under a license issued by the state in a reserved forest area, the cattle excreted. A reserved forest is, as you know, a statutory category under the Indian Forest Act in which the state exercises strict control. The state argued that this excrement became state property by virtue of the fact that the cattle were grazing on reserved forests and that their droppings constituted minor forest produce. In principle, the court did not agree to this line of reasoning. The time or the resources spent by the state to claim sovereignty over shit. But it also took some time to close the matter, and therefore, pending the final decision, the court agreed that the dung be sold to the state. It also graciously increased the price of this transaction. So the result was that the state asserted its right over dung. As you will now learn, it is the criminal law in the forest that drives the legal system to a point where shit needs to be owned and its ownership contested. So much so that the possession of shit in a forest invokes the criminal justice system. The Indian Forest Act 1927, under which this case came up, is a colonial legislation that superimposes the sovereign authority of the state in forests. In Chainpura, the Act had created a category of reserved forests through the regular three-step process. So after a forest becomes reserved forest under the IFA, a range of traditional activities, including access to the forest for various resources, are criminalized. Section 26 lays down a long list of such activities. And where a question arises whether some forest produce is the property of the government, under Section 69, it shall be presumed that it is, unless the contrary is proved. So if cow dung is forest produce, then the IFA presumes that it is the property of the government. It is also presumed that where any person is found in possession of any forest produce within the limits of a reserved forest, then that person is a criminal offender. That person's crime is that of removing the forest produce without authority or permission. These provisions came into effect when India was a colony of the British, and most people never came to know that such a legal process had been conducted, which in effect made them criminals. Their traditional rights to forest and forest produced were extinguished, and property was created which was owned by the state. This was done in addition to the Criminal Tribes Act 1871, which declared a range of indigenous tribes like Paridhis, Banjaras, Kanjars, Meenas as being criminal by nature. So when we gained independence from the British rule, the expectation might have been to break away from such an authoritarian regime. Instead, what we had was a spectacle of land reform laws which did not factor in the forests and its dwellers. The post colonial government only reinforced and strengthened the paradigm. For example, where the colonial IFA would have punished cattle grazing or dung collection for a maximum of 2 years, this punishment rose to 7 years after independence. However, the Constitution of Independent India laid down some foundational rules in criminal jurisprudence which were as much applicable in forests as they were in other areas. The first principle of criminal jurisprudence is that penal provisions, like any law that defines an offense or a crime, and the punishment must be defined clearly, without any vagueness or uncertainty. The text of the law needs to clearly specify what the ingredients of the act would be. There is also a connected principle that ignorance of law is no excuse. In case of a conflict, a person cannot claim that she did not know that that particular act was prohibited by law. The courts would not allow it. Therefore, the requirement is that offences are clearly defined and laws are adequately published and made known to the public. However, if you look at statutes like the Wildlife Protection Act, Section 51 of the Act makes a catch-all provision that contravening any provision of the Act or any rule or order made thereunder by any person shall be guilty of a criminal offence. The WLPA creates numerous specific wildlife offences throughout its framework and at times creates strict penalties for them. And so, if a forest dweller living in an area regulated by the WLPA needs to understand which of her acts or movement could be an offence, she would need to read the entire act and frame a table like this. The second principle is that any person who is accused of an offence is presumed to be innocent until their offence is proved beyond reasonable doubt. Unless the legal process takes its due course and it is proven beyond reasonable doubt that the person is guilty, the person is presumed to be innocent. There is a long distance between the accused may have committed the offence and must have committed the offence, and the prosecution must traverse that distance. It must do so with reliable and cogent evidence. On several instances, the presumption of innocence was recognized as a human right by the Supreme Court. But the legal history of forests has been defying this basic principle. The stigma of tribes being declared as criminal by nature continues till date. Although the tribes were denotified in 1952, a number of reports and studies have concluded that the Criminal Tribes Act has a continuing unfortunate legacy that is hard to overcome. The Madhya Pradesh Jail Manual 1987, for example, includes in its definition of a habitual offender that a person from denotified tribe would be a habitual offender by their identity. Further, if what had happened in Chainpura had happened in a reserved forest in Odisha, and the people from a tribal community would have been caught picking up excreta from their grazing cattle, then the Odisha Forest Act would have presumed that he is guilty of removing the forest produce without authority until the contrary is proved. A third principle of the criminal justice system is that the power of all government agencies and officers is limited. Article 14 of the Constitution strikes at arbitrariness because an action that is arbitrary must necessarily negate equality. In this context, Article 14 holds a fundamental concept. It states in unequivocal terms that every accused has a right to a fair procedure. In the administration of justice, no officer of the police or court is above the law, and therefore they cannot exercise an arbitrary attitude. In constitutional jurisprudence, we call this the rule of law. But this fundamental principle is defied in the provisions of compounding of offences in forest laws. Compounding of offences is a process of voluntarily admitting the contravention, pleading guilty, and seeking redressal. The IFA, for example, provides general powers to forest officers to seize any goods that they think are possessed or transported illegally. The law requires due process to be followed. These goods have to be produced before the Assistant Conservator of Forests with a report to the magistrate. But this process may be entirely overridden if the officer decides to compound the offence and accept monetary compensation instead. The recent proposed amendments to the Wildlife Protection Act, which also had similar provisions of compounding offences, has increased the limit of the amount of money for which an offence can be compounded to up to 5 lakh rupees. If the amendment succeeds, officers under the WLPA would be able to demand up to 5 lakh rupees, mostly from people who live in close proximity to protected areas. It is unsure how a fair law can empower a forest officer to this extent, where they can legally ask for a sum of up to 5 lakh for compounding of offences. Such a law, if passed, would infringe the basic principle of rule of law. It would instead be a rule of officers. A fourth important principle of criminal jurisprudence lies in Clause 2 of Article 20 in the Constitution. It provides protection against double jeopardy, meaning that no person shall be prosecuted and punished for the same offence more than once. For each act that amounts to an offence, there can only be one punishment. But this simple idea gets easily lost in translation. For example, if a forest dweller is booked for encroachment of state property and charged under criminal law, according to this principle, the act of the offence and the act of punishment should have been completed. In states like Odisha, however, different legal procedures need to be carried out for evicting that person from that property. And if the state fails to institute those procedures and the person continues to occupy that property, under the principle of double jeopardy, that person cannot be prosecuted again. The fifth principle is enshrined under Clause 3 of Article 20. It provides what is called in law as a fundamental right against self-incrimination. Any person who is accused of an offence cannot be compelled to be a witness against themselves. Since the law cannot presume under any circumstances that a person is guilty without evidence, it also cannot compel the accused to produce any evidence, like a statement or document, to prove their guilt. Giving effect to this fundamental right are the provisions in procedural laws that deny any admissibility to confessions that are given to police officers. The WLPA gives enormous powers to authorized wildlife officers to conduct investigations and collect evidence, including receiving and recording of evidence. Wildlife officials have been known to use this power to extract confessions from accused persons while in their custody, and then place these confessions on record during trial, even though the law relating to evidence categorically prohibits the use of confessions made to police officers during trial and violating the fundamental right of the accused. The Forest Rights Act in 2006 comes to undo historical injustices and change the substantive law of forests. It converts forest dwellers from being criminals under various statutes to being the rightful occupiers of forests. And now, the presumption about these people is not that they are forever criminal minds, but that they are right holders. Preliminary offense reports against forest dwellers for forest crimes or occupation of land are now part of the evidence that these people hold, occupy, and live in coexistence with the forests and have been doing so for generations. So, preliminary evidence of crime is now a part of evidence of a pre-existing right. So now the cattle can peacefully excrete without being subjected to ownership battles. The courts may have some more difficult cases to handle. In the next video, we will learn how the Prevention of Atrocities Act can further forest rights. Thank you for watching.